behalf of Mr. Stephen, who appears via Zoom. Sir, can you please state your full name to the court?
Yes, my name is Gabriel Alexander Stephen.
All right.
Right out of the gate, this case sets up something far deeper than a simple theft. It's about trust, access, and the kind of violation that doesn't just take property, it reshapes how someone lives their life. You've got a maintenance worker, someone who is literally given access to private spaces, accused of taking items from an apartment he believed was abandoned. That alone raises a critical legal and ethical question. When does assumption cross into criminal intent? And more importantly, who pays the emotional price when that assumption is wrong? But here's where this case takes a sharp turn. Among the stolen items is something that cannot be replaced, something insurance can't fix, a handmade possession from the victim's late grandmother. That instantly elevates this from a standard property crime into something much more personal. Courts don't just weigh financial loss, they weigh impact. Emotional trauma, sense of safety, long-term consequences, these all become part of sentencing. And as this unfolds, pay attention to the contrast you're about to see. On one side, a defendant claiming misunderstanding, lack of intent. On the other, a victim describing a life permanently altered. The question becomes unavoidable. When harm is real, does intent even matter as much as outcome? And by the end of this, you're going to have to decide, was this a mistake or something far more serious?
Thank you, Your Honor. Today is the date and time set. I have had the opportunity to review the PSIR with Mr. Stephen. We have not changed his court corrections. We respectfully requesting the court to adopt probation's recommendation. Mr. Stephen is as to the fines and costs. He is currently actively seeking employment, has not yet secured it. I did provide him with the ability to pay for him to submit to the court. We are asking for a payment plan as arranged by probation as to the fines and costs. Outside of that, we're asking the court to adopt probation's recommendation.
And Teresa Claire on behalf of probation. Your Honor, the victim, Phoenix Wesson, is here present today. She would like to address it.
All right. Very good. Ma'am, come on up. Hello. What's your name?
My name is Phoenix Blossom.
All right. What would you like to tell the court?
I have a pre-written statement here.
Go ahead.
Your Honor, my name is Phoenix Blossom, and I am the victim of the crime committed by the defendant, Gabriel Stephen.
This is where the courtroom dynamic shifts completely. Victim impact statements are not just formalities. They are often the most powerful moment in sentencing hearings. Legally, they give the judge insight into consequences that go beyond police reports and evidence logs. And emotionally, they anchor the case in reality. Notice how Phoenix isn't just listing what was taken, she's explaining what was lost. There's a difference. The law categorizes items as property, but for victims, these items often carry identity, memory, and connection. That's why courts allow this kind of testimony. It humanizes the case. And here's something critical. She mentions the item from her grandmother. That immediately transforms the weight of this crime. Financial restitution can be calculated. Sentimental loss? That's immeasurable. Judges take that seriously when deciding whether probation is enough or if stronger penalties are justified. Also pay attention to her tone. She's composed, but you can hear the underlying weight. That balance, controlled emotion with clear impact, is incredibly persuasive in court.
In December of 2023, my apartment at the complex where Mr. Stephen was working as a maintenance employee was broken into, and among the items stolen from that unit was a personal possession of my late grandmother's, which is the only item that has thus far not been recovered. This crime has had a profound and lasting impact on my life, and I am here today to share with you the impacts that I continue to experience. Violation of my personal space left me feeling vulnerable and unsafe in my own home. I chose in 2024 to move out of that apartment unit to another one, and likely will move yet again this year out of my apartment complex altogether due to its emotional associations with the crime. The sense of security I once had living by myself has been shaken, replaced by a constant fear that if I were not more vigilant, it could happen again. I find myself checking locks multiple times, double-checking items in my possession when I leave home, and making sure everything is where I left it when I arrive back. I no longer allow maintenance units from the complex into my home when I am not there, and always get anxiety attacks if and when there have been such entrances without my knowledge or approval, which is also motivating my desire for departure. This ongoing anxiety has affected my ability to focus fully when away from my home, my relationships with others whom I no longer allow in my current home, and in many ways my overall quality of life. I have ongoing sessions with my therapist, and it has been helping me to take back some measure of control and acceptance of lack of control over some things in my life. But still, I would not wish this level of anxiety upon anyone. Adding to the emotional distress I face with the loss of my grandmother's possession. This item held immense sentimental value as it was made by her by hand to the month and year that I was born, and represents a tangible connection to a woman who was a significant positive part of my life. We and her family all treasure the things she left behind for us, pieces of her presence in the world that are all we have left to hold on to after she was taken from us. To this day, I am still reluctant to accept gifts offered to me by family, especially those that were made by her, out of the fear that my current housing situation is cursed, or that I am cursed, and that they will be lost forever as well. I still call it her quilt, because in my mind, I was merely a guardian for it, protecting that part of her spirit that she left behind me. And I feel that I failed in my job.
This line right here is devastating and legally significant in a different way. Victims often internalize blame, even when they are not responsible. That emotional burden adds another layer to the harm caused. Notice what she's saying. She feels like she failed to protect something meaningful. That's not just grief, that's guilt. And guilt like that can linger far longer than the initial event. From a courtroom perspective, this reinforces the depth of impact. Judges are listening for exactly this kind of emotional consequence. It tells them that the damage wasn't temporary. It altered the victim's sense of responsibility, memory, and identity. And here's where it gets complex. She explicitly says she doesn't want punitive sentencing. That introduces a tension. On one hand, the victim is asking for fairness, not revenge. On the other, the court still has a duty to enforce accountability. So now the question becomes, should sentencing reflect the victim's mercy or the full weight of the harm described?
Over a year has passed since the crime, yet the emotional wounds for me still clearly remain. I continue to struggle with feelings of anger, sadness, and fear. At the same time, I have never wished for this sentencing to be punitive in any way. I've had some payout by insurance for the loss of my grandmother's quilt, so financial recompense is not something that I am looking for either. I simply want there to be justice, fair and fitting of the circumstance, and an understanding going forward that this should not happen to anyone else. I don't know the defendant's situation. I don't know if they were struggling as badly as I was during that time or felt desperate. It's not for me to know. I just hope that by sharing my experience here, that there will be a general understanding of the gravity of the defendant's actions and the lasting impact they have had, and how I would not wish for this to happen to anyone else. And I ask, Your Honor, that you may consider that impact as well when determining the appropriate sentence for this case, so that there may be a better way going forward for all parties involved. Thank you for your time and consideration. This concludes my statement to the court.
Thank you.
Thank you, Your Honor. As to the recommendation, I have been able to review that with Mr. Stephen, and I believe it is a fair and appropriate recommendation. Would ultimately ask the court to adopt it. Mr. Stephen has been very communicative with me in this process, and I do believe that he will do very well on probation. He is currently, as I did state prior, he is actively seeking employment, just as to fines and costs, respectively requesting a payment plan as arranged by probation. Mr. Stephen presents to the court with no criminal history, and I would ask that the court adopt probation's recommendation.
Does your client know where the quilt is?
No, Your Honor. To add a little context to the offense, Mr. Stephen was a maintenance worker at an apartment complex, and he was in an apartment that he believed to be abandoned. He did take items that he should not have taken. He did return those items. He states to me that he does not recall a quilt being in those items, and unfortunately did not even see a quilt while in that premises. There were other items that were taken, and he acknowledges that, and he did return them. His original intention when he believed that the property was abandoned was to resell them to support.
This is the defense's central argument, and it hinges on intent. In criminal law, intent can significantly affect how a case is viewed. If someone genuinely believed a property was abandoned, that can reduce perceived culpability, but it does not eliminate responsibility. Here's the issue. Assumption is not authorization, especially in a role like maintenance, where access is granted under strict boundaries. The expectation is higher. You don't just get to decide a unit is abandoned and act on that. Also notice the contradiction being introduced. He admits taking items and intending to sell them, yet claims misunderstanding. That creates tension in the narrative, because if the goal was resale, that suggests awareness of value and ownership. And then there's the missing quilt. He claims he never saw it. Why, that becomes a key unresolved element in the case. No recovery, no explanation, just absence. So now viewers are left with a critical question. Do you believe this was a misunderstanding or selective memory?
However, did return all items, and he was never in possession of this quilt. And Mr. Stephen, I should add this, to be candid with the court, when we've had a couple of conversations with Mr. Stephen, he's expressed he wished he knew where the quilt was, because he did at one point literally even say to me, that was my grandma's quilt, I'd want it back too, and I wish I knew where it was so I could give it back to the individual. But unfortunately, that was not one of the items that was taken and returned.
Mr. Stephen, anything you want to tell the court before I impose sentence?
There was a very special situation with me as a maintenance technician. The management was going through a lot, and the plaintiff has experience, as I recall, after I discovered who I had made the accident with. I had been the face of that for even installing the kitchen faucet sink even, or the sink's faucet. The apartment has shared laundry. I know laundry gets taken from the machines and there's no cameras or anything of the sort. Like I've said and stated, even since the beginning, that was never one of my intentions, was to keep anything or take anything from somebody who was still living there.
This is the defendant's moment, and it's all about credibility. He's emphasizing lack of intent, cooperation, and honesty. Those are the three pillars defendants rely on during sentencing to reduce severity. But listen closely. He acknowledges taking items, returning them, and misinterpreting the situation. That's partial accountability. However, partial accountability doesn't always equal full responsibility in the eyes of the court. He also brings up working conditions, communication issues, and lack of clarity in his role. That's a subtle attempt to shift context, to suggest this wasn't purely individual wrongdoing, but influenced by environment. Judges weigh this carefully. They look for genuine remorse versus strategic explanation. And here's the key factor. Does his explanation align with the facts already established? Because ultimately, intent may explain actions, but it doesn't erase impact.
There were signs that nobody was living there at the time, and I guess that was misinterpreted along with the communication from my supervisor, which was quite common. It seems in this area of work as a apartment maintenance, it's very critical and specific to our area. We're not quite treated the best. All I can say is I've been honest from the beginning. If I had the blanket, I would have given it back from the beginning, just like I gave everything else back. I had no ill will and wish no ill intentions for the plaintiff. That's all I would like to say, I guess.
Thank you. So sentence of the court, place the defendant on 12 months prosecutor deferred sentence. He is to pay $655 fines and costs, $360 probation oversight fees. When are you going to pay that, sir? Do you have anything today?
Right here, the judge begins outlining the sentence, and this is where everything comes together. Financial penalties, probation conditions, substance restrictions, community service. This is a structured attempt to balance punishment with rehabilitation. Notice the layered approach. It's not just about paying fines. There's employment requirements, drug testing, theft classes. These are corrective measures. The court is saying, you made a mistake. Now prove you can function responsibly moving forward. But then comes the key detail, 365 days in jail, suspended. That means the sentence exists, but it won't be served unless probation is violated. This is essentially a warning backed by real consequences, and when the judge asks about immediate payment, it introduces another dimension: financial strain. The defendant admits paying would create hardship. Courts often consider this, but they still expect accountability. So here's the question: is this sentence fair, too lenient, or appropriately balanced?
I have the full amount I could pay today, but it will definitely put me in financial burden as I'm on unemployment and have recently had to
How
move.
much can you pay today?
$500.
$500 today. And then when can you pay the balance of that?
I have by next month, May 23rd, so I have time to secure.
$500 today. The balance will be due by May 23rd, 2025. Okay. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to complete that as directed by probation. You're to complete 25 hours of community service. You're to maintain employment. You're to basically, I guess, find and maintain employment with verification to probation. I'll set a review hearing. That's to be held April 8th, 2026, 9 a.m. I will order 365 days in jail. Credit 2 days. The balance is suspended. Thank you.
Thank you, Your Honor. Thank you, Mr. Stevens. You're all set for today.
Thank you for your help.
Versus Gregory Garrison.
Thank you, Mr. Burton, sir.
Garrison. Thank you.
Teresa Claire on behalf of probation, Your Honor. Mr. Garrison is before the court for a violation of probation. Mr. Garrison is in violation of the terms ordered by this court in that he owes a balance of $1,595. He's made no payments towards any of the fines set. He failed to complete the 90-minute alcohol awareness session with Anita Griffin, failed to complete the victim's impact panel, failed to report to probation, failed to comply with the Smart Start alcohol monitor, and had just dropped it off at the location. And Your Honor, I had recent police contact on March 26th of this year with Adrian Police Department. I did provide a copy of that report to the court. There was a 625G issued, and there's an alleged use of drinking with a PBT of a 0.11. Given the circumstances with Mr. Garrison and this being an OWI second offense, probation is recommending that Mr. Garrison be sentenced to 365 days in jail with credit for 17 days served. That he is to serve the remaining balance. It's to waive remaining terms of the rest of the probation, accepting the financial obligations and discharging the probation.
All right. Does he wish to have a full hearing on this? He
No,
acknowledged.
Your Honor, I have discussed this with Mr. Garrison. We have discussed in detail both the alleged violations of probation as to the recommendation. As to the violations, candidly, Mr. Garrison, we had a very long, pragmatic conversation that yes, these violations did occur. The only thing he did want me to add and explain to the court is that he did state to me that yes, he violated probation while he was on his alcohol monitoring device. He does state that this was going back a few years ago. He did call probation after some time not being in contact with them. And of course, he was advised to turn himself in on, I believe at that time, or may have already been outstanding. He stated to me that, of course, he did not turn himself in, and looking back, he should have done so. He was very honest with me that he did mess up on probation, and he wishes he hadn't. He also stated to me that, yes, I have a drinking problem, and I have messed up on alcohol. He has no violent offenses in his history that I'm aware of. His only other pending matter is that new matter now with Adrian. He acknowledges he did mess up and is fully admitting that to both the court and to probation. As to the recommendation, he is asking that the court do not impose the jail time. I am requesting that he be discharged from probation without improvement except for the financial application, the remaining terms to be waived. For the alternate, I'm asking the court to consider an early release from jail if he were to complete the in-jail bond farm program. Mr. Garrison states to me that he did already sign up for the Dawn Farm in-jail program as well as AA classes since he was brought to the jail last week. His only other pending matter, like I stated, is that Adrian pending case. He resides there with his father. He has a very strong support network. He has 8 children, ages 2 to 22, that he fully supports. He owns his own business and works as doing preventative maintenance on vehicles. He does not have any violent allegations, to my understanding. He's a very hardworking family man who just acknowledges he does have a struggle with alcohol. And again, to that end, he did sign up for the Dawn Farm and Jail program, as well as AA classes in the jail. He's asking the court to consider not imposing the jail time so he can get back to work and supporting his children. He understands that he did violate his probation, but he's asking the court to discharge him from that without improvement and not impose the jail time. And I'm asking that in the alternate, if the court were to impose the jail time, that the court would consider an early release upon the completion of that program.
Sir, anything you want to say?
Yes, sir. First off, I'd like to apologize to you on the court for my actions. Secondly, I actually did complete the 90-minute assessment with Anita Griffin. I recall doing that. I spent a whole day in Ann Arbor doing that. Other than that, my actions speak for themselves. I just want to get better and do better and be a better person. I'm not riffraff. I don't cause other issues out in the community. And I'm apologetic for my actions.
Sends to the court, I'm going to order 365 days in jail, credit 17. The balance the defendant is to serve. I will waive the remaining terms except his financial obligations, discharge him from probation without improvement. Thank you.
The second case shifts the tone entirely, and the outcome reflects it. Unlike the first defendant, this individual admits repeated violations, unpaid fines, failure to report, ignoring monitoring requirements, and continued alcohol use. Legally, this is a pattern, and patterns matter more than isolated mistakes. Courts are far less forgiving when someone repeatedly fails to comply with probation terms. Even though he expresses remorse, acknowledges his struggles, and highlights responsibilities like supporting 8 children, the judge focuses on one key principle: accountability. Rehabilitation opportunities were already given. They were not followed. That's why the sentence here is not suspended. It's enforced. The court is essentially saying, you had your chance and you didn't take it. This contrast between the two cases is critical. We're sure one defendant gets a structured second chance. The other faces immediate consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.